10:30, so we will call the Senate Judiciary Committee to order. And our first order of business is request for bill introductions. Do we have any request for bill introductions? Yes, go ahead and approach the podium and please introduce yourself and welcome to committee.
Morning, Madam Chair. I'm Greg Smith, Special Deputy for Government Affairs with the Johnson County Sheriff's Office. And we would like to introduce, it's RS 0645, has to do with clarifying certain regulations concerning evidence collection practices.
Thank you. Seeing no objections, the bill is so introduced. Thank you. Any other request for bill introduction? Senator Corson.
Thank you, Madam Chair. I have bill introduction. It is 21 RS 0858. This is creating the crime of deprivation of rights under color of law and providing a civil action for victims. I have 21 RS 0857, providing for payment of interest in civil actions for wrongful conviction and directing the Attorney General to seek damages from the state for any person who knowingly contributed to the wrongful conviction and prosecute ouster criminal proceedings as warranted. 21 RS 0855, increasing criminal penalties for hate crimes. 21 RS 0961, enacting the Uniform Partition of Heirs Property Act. And one more is 21 RS 1122, which is a law enforcement related bill. Thank you.
Thank you, Senator Corson. Any objections? No objections, so the bills are so introduced. Yes, please approach the podium, introduce yourself, and welcome to committee.
Jeff Wagaman from Steve Kearney and Associates. I have a bill introduction from Mr. Kearney. It is 21 RS 1020, an act prohibiting defense counsel from asking for a psychiatric examination of victims, particularly in sex crimes.
Thank you. Seeing no objections, the bill is so introduced. Thank you. Any other requests for bill introductions? Just a moment, committee. I have one. I need to pull up the RS number, though. Thank you. It is 21 RS 0921, enacting the Fairness in Condemnation Act, imposing certain duties on the plaintiff, condemning authority, notice, and opportunity for negotiation. Seeing no objection, the bill is so introduced. Any other request for bill introductions? Seeing none, then we will move on to a reminder that today is the final day for bill requests in this committee. And we will then open the hearing on Senate Bill 103, and just want to point out that several of our committee members are participating by WebEx today, and per the Senate rules, unless the committee member is on WebEx in the building today in the Capitol, there won't be any questions asked from committee members on WebEx. So with that, then if we could have a bill brief from the reviser, Mr. Thompson.
Thank you, Madam Chair. Good morning, committee. Senate Bill 103 amends the Kansas Power of Attorney Act regarding the form of a power of attorney and the duties of third parties relying and acting on a power of attorney. The bill was requested on behalf of the Judicial Council, and I see they have a conferee here that can get into a lot of the details for you. I will also note that the bill was heard last year. It was House Bill 2500. It was amended in the House Committee, and then in the Senate Judiciary Committee, some amendments were proposed, but the bill did not end up getting worked or sent to the Senate, as far as I recall. But this new version of the bill incorporates all of those amendments, both the ones made by the House and then the subsequent amendments recommended to the Senate Committee. So this is a proposal that will look familiar to most of you. The first section amends KSA 58-652 to provide that a power of attorney executed on or after July 1 of 2021 will be deemed sufficient if in substantial compliance with the form that the Judicial Council will create. The section requires them to then create that form. And then all the amendments to this section apply prospectively, so it will not affect the validity of a power of attorney executed prior to July 1st of this year. Section 2 amends KSA 58-658. That's our statute addressing exemption of third persons from liability when they're relying and acting on a power of attorney. There's several changes in here that I won't get into the details of. I'll leave that for the conferees, but I do detail them in the bill brief. And particularly, I would focus on new subsections F through I. There's a paragraph about all of the changes in there that are really the changes that were adopted last year in the House Committee about acting in good faith and certification provided by an attorney in fact, and those sorts of issues. I'll stand on the bill brief for now and see if you have any questions.
Thank you, Mr. Thompson. Committee, are there any questions for the revisor? Seeing none, then we will ask our proponent conferee today, Mark Naffendoffel from the Kansas Judicial Council. Please introduce yourself and welcome to committee. It's up to you. Thank you. And make sure you turn your microphone on and speak clearly directly into the microphone so those on WebEx can hear you.
That work okay?
Yes, just make sure you speak into the microphone so you can be clearly heard. Appreciate it.
My name is Mark Knockendoffel. I work as a trust officer with a trust company located headquartered in Manhattan, Kansas, and have been in the trust business for 38 years. Here as a member of the Probate Law Advisory Committee of the Kansas Judicial Council to recommend approval of this bill. We've been working on this bill for about 3 or 4 years in consultation also with the Kansas Attorney General's Office, Kansas Bankers Association, and the Kansas Bar Association, and we believe that we've come up with a good compromise of, I think, a universal commitment to make this a better bill for both principals who are adopting these documents, also to the agents who are carrying them out, and the third parties who must be accepting them. And the focus of this bill primarily is to encourage the greater acceptance of durable powers of attorney by third parties, either without taking on any liability, or also in some situations where a third party is reluctant to accept them for very good reasons. What I often refer to as the smell a rat type of situation where somebody is using one without the best of intentions. So based on that, we recommend this bill, which, like I said, was a good compromise, and we think will support the adoption and use of durable powers of attorney. Any questions?
Thank you. Any questions from the committee? I do recall this bill from last session, and there were concerns raised about whether the third person relying on the power of attorney could do so even though there might be some reason to question the validity of the power of attorney. The third person doesn't have actual knowledge of a problem with the validity or authenticity of the power of attorney. So how have the amendments addressed that concern? You don't have actual knowledge as the person relying on the power of attorney in a transaction, but there would be enough what I would call red flags for you to accept and act on that power of attorney. What place guards do we have in place? Excuse me, safeguards.
The bill has a provision now that allows that third party to request an opinion of counsel from the agent. And previously, I believe that bill had a requirement that they had to provide it. And we thought that was going to be a problem because there will be some third parties who, in every situation, they'll request an opinion of counsel. But in this case, they can request an opinion of counsel and then rely on that opinion of counsel as to the validity and the circumstances under which that durable power of attorney was being presented to that third party. think that's a reasonable approach.
Thank you. Are there any other questions from the committee? Seeing none, thank you for appearing today on this cold weather day, and the roads are kind of rough, which I think is why we have a lot of committee members appearing on WebEx today. With that committee, then, I will direct your attention to the proponent written testimony, Ashley Garr, Kansas Land and Title Association. And I will make a request then, are there any other proponent conferees in the committee meeting room or on WebEx? Seeing and hearing none, I will request, do we have any neutral conferees either in the committee room or on WebEx? Seeing and hearing none. Any opponent conferees in the committee meeting room or on WebEx? Seeing and hearing none then. With that committee, we will close the hearing on Senate Bill 103 and open the hearing on Senate Bill 107. If we could have a bill brief from the reviser, Mr. Thompson.
Thank you again, Madam Chair. Jason Thompson with the Revisor's Office. Senate Bill 107 enacts the Uniform Fiduciary Income and Principal Act and repeals the Uniform Principal and Income Act from 1997. Again, this is a request from the Judicial Council, and they have an expert conferee here to give you a lot of detail if you desire. This will look very familiar from last year. This was House Bill 2554. And the only change made from last year's bill to this year's bill was to change the effective date to 2021. So I was able to reuse my bill brief. As you can see, if you look at it, it's about 3 pages, one of the longer ones. So I will not go into all the detail that's provided there, but very briefly stated, you can see that Section 1 names the act, Section 2 gives you the definitions, and that's really a key piece of seeing what the bill is about with the Uniform Fiduciary Income and Principal concepts. Section 5 is where the duties and powers of a fiduciary in making allocations or determinations or exercising discretion under the act. So that's a good section to look at. Fiduciary decision is defined in Section 6. And then Section 7 gets into adjusting between income and principal. And then Section 8 through 16 kind of gets into converting to a unit trust, what actions a fiduciary may take and when they can adjust, some notice requirements and the manner in which a consent can be made, items that have to be in a unit trust policy, rates that can be used in a unit trust policy, methods for determining fair market value, and various other provisions. And then toward the end of the act, you get the standard provisions about uniformity of this uniform law, the applicability of it, that it will apply to a trust or estate existing or created on or after July 1st, except as otherwise expressly provided in the terms of the trust or in the act, and then the severability, and finally one amendment to current law in 58A-103, dealing with the definition of the terms of a trust. So very shortly stated, a uniform act replacing a prior uniform act. It's about 49 sections. One of them amends a current section in the Uniform Trust Code. And I'll stand on the bill brief and see if you have any questions.
Mr. Thompson, committee, do we have any questions for the reviser? Seeing none, we will welcome the proponent conferee back to the podium, Mr. Mark Knackendoffel from the Kansas Judicial Council. Please introduce yourself again and welcome back to committee.
My name is Mark Knackendoffel. I serve as the CEO of the trust company located in Manhattan, Kansas, and I'm also here on behalf of the Probate Law Advisory Committee of the Judicial Council. This is a bill, the Uniform Fiduciary Income and Principal Act, which has been adopted in, how many states was it? I forget now. Anyway, this bill is an update of the bill that was passed in Kansas 20 years ago, and there have been some changes that we think are worthwhile, some clarification of language, also expansion to apply to other types of financial instruments that weren't covered previously. It also provides greater flexibility in use of the Principal and Income Act. And then also there are more detailed unit trust provisions, which was a fairly a novel approach that Kansas adopted in 2009, even though there was not a uniform act addressing that yet. And so this would now have uniformity across other jurisdictions. Finally, there's a provision now that clarifies which state's law applies, which is real important. We didn't have that before. So we think it's a great improvement to the Principal and Income Act, which is something that we use on a daily basis in the trust business. With that, we recommend approval.
Thank you. Do we have any questions for the conferee from committee? Seeing none, I'll ask then, do we have any proponent conferees in the committee meeting room or on WebEx? Seeing and hearing none, do we have any neutral conferees in the committee meeting room or on WebEx? Seeing and hearing none, do we have any opponent conferees in the committee meeting room or on WebEx? Seeing and hearing none then, we will then close the hearing on Senate Bill 107. And we will open the hearing then on Senate Bill 141. If we could have the bill brief from the reviser, Mr. Thompson.
Thank you again, Madam Chair. Jason Thompson with the Revisor's Office. Senate Bill 141 enacts the Kansas Uniform Directed Trust Act. This is another bill requested by the Judicial Council, but this is a new Uniform Act request, so I'll give you a little more detail on this one than the other. Section 1, of course, names the act, the Uniform Directed Trust Act. Section 2 provides definitions, and I'll highlight directed trust, which is the key term for what we're talking about here. That means a trust for which the terms of the trust grant a power of direction. And that term, power of direction, means a power over a trust granted to a person by the terms of the trust, to the extent the power is exercisable while the person is not serving as a trustee. But it excludes certain powers described in Section 5 that we'll get to in a moment. So Section 3 of the bill then provides for the applicability of the act to a trust whenever created that has its principal place of administration here in Kansas. If it was created before July 1st of 2021, the act applies only to a decision or action occurring on or after July 1 of this year. If the principal place of administration of the trust is changed to this date on or after the effective date, the act applies only to a decision or action occurring after that date. Section 4 provides that the common law and principles of equity supplement the act, except to the extent modified by the act or the law of this state that's otherwise found outside this act. Section 5 then provides that list of powers that the act does not apply to, and the biggest one is the power of appointment. Section 6 then provides that terms of a trust may grant a power of direction to a trust director, and unless the terms of your trust provide otherwise, that trust director may exercise any further power appropriate to the exercise or non-exercise of that power of direction granted to them. And trust directors with joint powers must act by majority decision. Section 7 then provides that a trust director is subject to the same rules as a trustee in a like position and under similar circumstances in the exercise or non-exercise of certain powers, and I've highlighted a couple of those in the bill brief. Section 8 then imposes certain fiduciary duties and liabilities on a trust director and provides that the terms of a trust may impose additional duties and liabilities. Section 9 provides that a directed trustee must take reasonable action to comply with the trust director's exercise or non-exercise of a power of direction or further power, and that the trustee is not liable for that action. Section 9 does also provide that a directed trustee must not comply with that director's exercise or non-exercise or further power to the extent that by complying, the trustee would engage in willful misconduct. So they have to comply unless it's going to engage in willful misconduct. Section 10 then requires a trustee to provide certain information to a trust director and requires a trust director to provide certain information to a trustee or another trust director. Section 11 provides that certain duties are not imposed on a trustee or trust director unless the terms of a trust provide otherwise. Section 12 provides the terms of a trust may relieve a co-trustee from duty and liability with respect to another co-trustee's exercise or non-exercise of a power. And Section 13 then provides that an action against the trust director for breach of a trust must be commenced within the same time limitation provided in KSA 58A-1005, and a report or accounting has the same effect on that limitation period as it would under that statute. Section 14 provides that in that kind of action for breach of trust, the director may assert the same defenses a trustee in a like position would be able to assert. Section 15 provides that by accepting appointment as a trust director of a trust subject to our new act, the director submits to personal jurisdiction of the courts of this state regarding any matter related to that power or duty of the director. Section 16 provides that certain rules applicable to a trustee apply to a trust director unless the terms of a trust provide otherwise. And then finally, we get into the sections dealing with uniformity, the impact on the electronic signatures in Global and National Commerce Act that you see in every uniform act these days. That's section 17 and 18. And then section 19 gets into our amendatory provision, again, amending the definition of terms of a trust over in 58A-103, amending in section 20, 58A-105 concerning the duty of a trustee to act in good faith and administer the trust. Section 21 is 58A-603, to provide that while a trust is revocable, the trustee may follow a direction of the settlor that is contrary to the terms of the trust. And finally, section 22 amends KSA 58A-703, regarding co-trustees, to make those provisions subject to section 12 of the new act. So all in all, you have about 16 substantive sections, a couple of standard uniform law sections, and then 3 amendatory sections at the end of the bill. And I will see if you have any questions.
Thank you. Committee, any questions for the revisor? Mr. Thompson, I have one. So this is enacting a wholly new Uniform Directed Trust Act in Kansas, is that right?
Yes, Madam Chair. My understanding is that there are scattered laws about directed trusts in other states, but Kansas does not have one. And this Uniform Act would be our first act on directed trusts.
Thank you. Committee, any questions for the revisor? Seeing none, then we will invite the proponent conferee, Mr. Mark Knackendoffel, Kansas Judicial Council, back to the podium. Welcome again.
Thank you, Madam Chair. Again, my name is Mark Knackendoffel, serve as CEO of the Trust Company located in Manhattan, Kansas, and here on behalf of the Probate Law Advisory Committee of the Kansas Judicial Council. Again, this is a new act. The concept of a trust director or a trust protector, which I think is a more common term, at least in these areas, have been used for a number of years, but previously we had no type of statutory framework for the use, powers, liabilities associated with powers exercised by trust directors or trust protectors. And so we believe this is a positive step in terms of providing guidelines for the administration of trust powers in conjunction with both trustees and trust directors. I think it's pointed out in the written testimony that 13 states so far have adopted this, and the Kansas version or proposal in the bill makes no substantive changes to the Uniform Act. We looked at it closely, determined that the provisions were very acceptable to our committee, and as a result, we recommend approval of this bill and adoption of the Uniform Directed Trust Act. Any questions?
Thank you. Committee, any questions? I have one question. If you could explain for those who may be listening online, how does generally the trust director, if there's a conflict between what the trust director would like the trustee to do and how is that resolved? Does this act help resolve that?
I'd have to go back and look specifically, but usually the trust director is going to sort of trump the trustee the sense that they're, if it's within the confines of their stated authority, the trustee is obligated to abide by the direction of the trustee. If there is a conflict, it would end up in litigation typically.
And does the act then apply retroactively? I mean, there were trusts that have been in effect for many years before this bill were to become law would be enacted, and then so those folks who have created trusts at the time didn't envision that there would be a trust director who could trump the trustee that they created at the time they created the trust.
I'd have to go look at the details of the bill, but I believe that it's going to provide terminology, the relationship between trust directors and trustees, also provide a requirement that all parties act in good faith. But in terms of the retroactivity, it will apply to previous trusts. But the powers that are created, I think, will be, because we didn't have any statutory guidelines before. So now this will be the first adoption of a statutory framework. So I believe that it would be retroactive to those previous trusts.
Do you know, has this resulted, oh, sorry, is there someone who can help answer the question? Or that you
I was just referring to Ms. Molson and see if she had any, if she was confirming my opinion here.
Okay, great. And let me lose my train of thought there for a moment, but in the other states that have adopted this Uniform Directed Trust Act, do you have any information about, has there been an increase in litigation regarding any conflict between the trust director and the trustee, or has that been a problem in other states?
I don't know, and this is pretty new, so there probably hasn't even been enough time to have conflicts develop and have been to have been litigated at this point. The first knowledge we had of the Uniform Directed Trust Act was about 2 years ago, maybe 3. But in the testimony, I don't see when it was actually established by the National Commissioners on Uniform State Laws.
And how many states did you say have adopted this?
13. And the closest to Kansas are Nebraska and Colorado.
And without this act, then does a trust director have any authority to direct a trustee to take
It would all be dictated by the terms of the document.
in terms of the trust
Yeah,
document?
the trust itself.
Okay.
So that's why it's helpful to have some guidelines that fill in a lot of the blanks, so to speak.
Thank you. Senator Wilborn?
Thank you, Madam Chair, and thank you for the testimony. I have a quick question. Will some of the existing trusts have to be modified to reflect this change?
It's a good question. I would think not, unless there is a conflict with the document itself. The other difficulty with these is many of these are irrevocable trusts. I would say in most cases, trusts that involve trust protectors or directed trust directors would be irrevocable and unamendable anyway. Unless there's some kind of conflict with state law in adoption, but I wouldn't think that they would either be amendable. And typically the grantor is probably deceased at that point. So they can't amend them. And I might point out, one of the reasons these are used is that the grantor of the trust, the person creating the trust, is concerned about having additional flexibility and some sort of third-party oversight to do what the grantor could have done had it been an irrevocable or irrevocable trust during their lifetime. And so what they want to do is appoint somebody who can be a third party to watch over the trustee, one of the common powers we often see as a trust protector or trust director is the power to change trustees. So if they don't like what the trustee's doing, this is inconsistent with what the grantor would have wanted, that trustee's out and the trust director steps in and appoints a new one.
Thank you, Madam Chair. One more question. I did not read the bill, so that's my fault. Does this have any provisions to decant the contents of one trust to another trust?
No.
Okay, thank you.
Oh, okay, I'm sorry. Yeah, the question was about decanting. Our committee is actually working on that right now as we speak, but it's not part of this bill.
Thank you, sir.
Yeah, and that's usually a power exercised by the trustee as opposed to a trust director. Okay, thank you so much.
Thank you. I have another follow-up question.
Okay.
You brought up an interesting point that we have an irrevocable trust or even irrevocable trust, and a grantor has passed and is deceased. Wouldn't a beneficiary, if a beneficiary was learning that the trustee was engaging in some malfeasance, couldn't the beneficiary request that the trustee be removed, like a trust director could?
The beneficiary does have that power. Those provisions are already included in the Uniform Trust Code that was adopted here in about 2003 or so, something like that. And so that's a little different power, but it is there in place to remove a trustee who's been accused of malfeasance or breach of fiduciary duty.
And if the trust director disagrees with the trustee, the trust director would have sort of super authority over the trustee. Is that what the bill provides?
That's my recollection. Again, it's been a number of months since I've read it. I've read it a couple of times, but didn't commit it to memory. And I believe that is kind of the essence of why the trust director has that, as you call it, superpower to override or direct the trustee. You know, the trustees kind of recourse, if they believe that is something that is improper, they could seek maybe a injunction against the exercise or some other type of litigation step to, if they believe that the trust director is not abiding by their fiduciary duty in making that direction.
Would grantors who created their trust prior to, if this bill were to be enacted, would they be surprised that there's now a trust director who could supersede the authority of the trustee that the grantor has?
I don't think so. I think that's typically what they're looking for when they appoint a trust director. They're giving them that superpower because they trust them, they have faith in their ability to make good judgments.
I guess my question was to a grantor who is now deceased. Would they, I mean, this is speculation, I suppose, but I would think a grantor might be later surprised that the trust they have created and entrusted the trustee that they've appointed with certain authority might then later be superseded by a trust director.
Well, the grantor is the one who appointed the trust director.
So I'm talking about a grantor has deceased, and then prior to the enactment of this bill were to become law.
Those trusts, if they don't have a trust director appointed in them at the time that they are created, this statute doesn't give anybody the power to appoint one.
Okay, great. That's kind of where my confusion was,
Okay,
and I
I see what you
apologize.
mean.
I
Yeah.
haven't
Yeah.
studied the details of the bill as much as I should.
Okay. This doesn't create any kind of power in any third party or a court or anything like that. That's something that the grantor has to do at the time that they create the trust agreement.
Got it.
They
Thank
would-
you. I wasn't clear on that. Appreciate that. Committee,
Yeah.
any,
In my career, I've been doing this 38 years. I've seen lots of trust documents that had trust protectors in them, but only one time ever have we been called upon to use the services of that trust director to make a decision for us. And it actually happened to be an appointment of a successor trustee.
very Very good. Thank you for answering all the questions. Committee, do we have any other questions? Yes, Senator Corson.
Senator Warren asked a really good question. Thank you, Madam Chair. So now I'm curious, who wins in a conflict between a trust director and a beneficiary? If they are in disagreement, how does that resolve itself?
And please make sure to speak into your microphone. The
Yes,
folks on
thank you. I
WebEx are
forgot
having
about that.
difficulty.
So the question is, what happens if there is a conflict between the decision of a trust director and the desires of a beneficiary? The trust director's decision is going to take precedence in that case. If the beneficiary believes that the exercise of that power by the trust director is a breach of their fiduciary duty, their recourse is to, seek file a petition with the court to have that decision voided. But under the terms of the document, the trust director's decision is going to be enforced. And their only recourse then is to sue the trust director.
Thank you, Madam Chair.
The beneficiaries are often at the, that's why the trust was created in the first place, is that perhaps the grantor wanted to make sure that those beneficiaries were subject to the, good judgments and actions of the trustee and the trust director.
Exactly, and I just want to make clear that I believe the draft of this particular bill wasn't finalized until I think Friday of this week, so the committee hasn't had a whole lot of time to study the bill. That's rather lengthy, so.
Enjoy your reading.
Right, so apologize, but it's something that I think the reviser has explained very well, you've explained very well, and answered the questions that we posed to you today, so. Appreciate you coming over in the bad weather today and the cold. So,
I had a bonus. I got my second vaccine shot earlier this morning. So,
well, there you go. It's kind of a twofer then. So, appreciate it. Good to see you. Thank you very much.
Thank you so much.
Committee, I will then ask for: are there any other proponent conferees in the committee meeting room or on WebEx? Seeing and hearing none. Are there any neutral conferees in the committee meeting room or on WebEx? Seeing and hearing none. Do we have any opponent conferees, either in the committee meeting room or on WebEx? Seeing and hearing none, then, committee, I will direct your attention. I do believe we have a fiscal note in your committee folder that says that it would result in collection of additional docket fees for those cases filed under the bill's provisions. So no impact other than that, it looks like. And with that, then, we will close the hearing on Senate Bill 141. And we will then not be working any bills today. We will reserve that for later this week, but committee, please always be prepared to pull out of your folder any bills we've previously heard. And with that, then, we are adjourned. Thank you.